In this module called the legal environment, we're going to look at a range of legal topics that somehow touch on business activity. So it's a little bit of a grab bag module because we're going to look at a number of different areas of law, each of which are actually their own course in law school. So we're only going to really skim the surface of these topics. But at least it'll give you a taste of the various different areas that at least are relevant to business activity. So we're going to begin by looking at ethics. And there are a couple of different large groups of theories of ethical behavior. And the two that I want to talk about are deontological theories and, on the other hand, consequentialist theories of ethics. Now, ethics has to do with the moral principles of right and wrong, how we decide what's best to do. And deontological theories are based on the idea that ethical behavior is guided by our duties or obligations. We need clear obligations to shape our actions, and that consequences are not the key thing. It's what we do. John Locke referred to those obligations as natural rights, and he focused in particular on things like life, health, and liberty. And he said that these are natural, meaning they weren't created by government. They are things that people have by virtue of being human. They're universal, they apply to everyone, and they're inalienable. They can't be transferred, they can't be bought, they can't be sold. And Locke's concept of natural rights is most famously memorialized in the Declaration of Independence, which states that human beings are endowed with inalienable rights to life, liberty, and the pursuit of happiness. Another influential figure in deontological theories was Immanuel Kant. And Kant talked about something he called the categorical imperative, which states that certain actions, regardless of their consequences, are actions that we must take as moral beings. And one of his core principles is that we have to treat people always as an end, not as a means to an end. For example, if there were if you had the chance to kill one person to save 5 people, and in Kant's view, you would not be able to do that because you'd be treating that one person as a means to an end. And he would say that it was immoral and unethical to kill that one person, even if it meant that you would save 5. Now, in contrast to deontological theories, consequentialism looks at ethical behavior in terms of its consequences and looks at whether an action is right or not based on its impact, not based on its motive. So it's not what you do, it's what the impact of what you do is. And the most famous theory of consequentialism is utilitarianism, which justifies actions as long as it does the greatest good for the greatest number of people. And the philosophers Jeremy Bentham and John Stuart Mill are the most famous advocates of utilitarianism. And to go back to my example, in utilitarianism, if you could save 5 people, that would be better than saving 1. And so if you had to kill 1 to save 5, a utilitarian would say that that was the ethical thing to do. So you can see that the different theories of ethics would lead to different outcomes. Now, legal ethics tend to embody these ethical concepts, and they essentially combine in various ways both deontological and consequentialist theories. Legal ethics refers to the rules of ethics that govern the practice of law and particularly the conduct of lawyers. Each state has ethical rules for lawyers practicing within the state, and there's also the American Bar Association has model rules of professional conduct. They're sort of like the uniform rules that we talked about earlier. They've created a set of rules that most states have adopted in some form or another. And if you violate those rules, you are likely committing malpractice. Malpractice is a tort action of negligence against lawyers for failing to satisfy the professional duty of care that they owe to their clients. So in order to establish a malpractice claim, you've got to show that the lawyer committed negligence and that it caused damage to you as the client. And obviously, if a lawyer violates an ethical rule, one of the ethical rules imposed by the state, then that's tremendous evidence of professional negligence and the fact that the lawyer has fallen below the standard of care. So what else do we need to know about what attorneys need to do in terms of legal ethics? Well, one key concept is attorney-client privilege. Attorney-client privilege protects the communications between an attorney and her client so that neither the attorney nor the client can be compelled to disclose those communications in court. So in order for that privilege to adhere, there must be an attorney-client relationship. So it can't just be that you have a friend who's an attorney who you chat with. That's not an attorney-client relationship. You have to actually enter into the relationship. And the communication was confidential. It wasn't disclosed in the presence of other people who are not part of that relationship, and it's not intended to be disclosed to others. And if that's true, then it's privileged. And importantly, the privilege belongs to the client, not the attorney. So that means the client can waive the privilege and ask the attorney to disclose the information, but the attorney cannot disclose the information unless the client consents. And that's even true, by the way, after the death of the client. The attorney still has to keep the confidence. We also need to focus on the conflict of interest rules connected to attorneys, because of course attorneys represent many different clients, and so there's always the possibility that you could represent one client and in representing one harm the interests of another. And so the model rules establish procedures regarding how lawyers should address potential conflict of interest. So first, the model rules limit the lawyer's ability to represent clients when there is what we call a concurrent conflict of interest. So a concurrent conflict of interest is when representing one client will directly be adverse to another client at the same time, or there's a significant risk that in representing one, I will not be able to provide effective representation to another. And the model rules say that the lawyer can't engage in that representation unless she reasonably believes that she'll be able to provide competent and diligent representation and the client consents in writing to the representation. And so that at least would address that particular concern. Now, a lawyer's ethical obligations also extend to former clients. So a lawyer cannot represent a client in a matter in which the client's interests are adverse to the interests of a former client unless the former client consents in writing to the representation. And also the lawyer can't use information from representing a former client in a way that would be disadvantageous to the former client or otherwise disclose privileged information, obviously. Now, the model rules also limit the extent to which lawyers can engage in business dealings with their clients. So a lawyer can't enter into a business transaction with a client or acquire an interest adverse to the client unless the client consents in writing, is given an opportunity to seek independent legal advice, and the terms and process by which the transaction occurs have to be objectively fair, reasonable, and fully disclosed in writing. So in other words, it has to be informed consent. So it's not just that the client has to consent, the client has to be fully informed, has to have the opportunity to seek outside counsel, and therefore it has to be fully informed consent.